Very warm good evening to all. Today we are going to discuss section 25 of the Indian Evidence Act. We all have heard the word extortion, but here the word extortion is used in a different way. The explanation of section 25, if we read and we understand, is extortion of the confession by the police authorities. So section 25 was enacted to put a ban on the police officer's power to extort the confession from the accused. See, anybody who is has done any crime, and if he goes to the police station and he makes a confession, possibly he will not be in a proper uh, sense of the his mind, or possibly he may be also in a position not to understand the implication of what he is going to do. So he is always better that the legislature has come out with this section of 25 Indian Evidence Act, which helps us that any person who goes to the police station goes without any fear, and if he records any statement and in a pressure or maybe due to police brutality or operation of the some police, maybe there is a position. See, police is always in a powerful position, and the powers may be misused by the police to get a promotion in the future, to get the conviction, and to get a better record of their career, and they can get a promotion. So in all this way, this section 25 is brought in by the Indian Evidence Act to put a ban or put a check on the confession which will be taken by the police authorities. Now section 25 says any person who goes and give any confession before the police, it will can never be taken as an evidence in the Indian Evidence Act, and it cannot be proved against him or her. So section 25 is one of the very important and powerful section, which actually from the defense side we should be knowing. There are some judgments, just because there was a confessional affair, that is the accused went to the police station and he gave a statement that I committed a crime, and in those conditions this confessional statement before the police was not accepted, and the prosecution has to stand on its own leg. That means it has to bring its own case to prove his case beyond the reasonable doubt against the accused, and the accused has a right to silence. That principle is taken by the our legislature, and because of this section 25 comes in the picture, and the principle underlying section 25 is that anybody who goes to the police station, if he makes a confession, that confession in the future cannot be used against him. To understand what is confession, let's say a person commits a crime and he goes to the police station, and if he says that I have committed a crime, the police may record his statement, and this statement will be a confession, but it cannot be used against him. Now there may be a question from all of us, including me, that if it is not useful by the police, uh, recorded by the police, and can be used in the court, then why first of all it is recorded? Why section 25 is there in Indian Evidence Act? When it is of no use, and it is putting ban on recording or the confession, or it is a it I would say it is not a ban on recording, but it is a ban on using the same confession. Now here when we say why first of all it is recorded, now let's understand why it is recorded. See, it is a source of information for the police to put the criminal law into motion. Suppose a person commits a crime and he goes to the police station and he says that I have committed a crime. Afterwards, when the trial runs, he may say that I have not made such a statement. He can take his own defense. He has a right to take his defense in a position, whatever maybe the situation he was in, maybe mentally or physically, he was not in condition to understand the implications of his whatever statement he has made before the police. Maybe it may have been made by the because the police motivated him, that, or may have forced him by using their power, that you will be if you tell the truth, or if you accept there that you have committed a crime, you will be punished lesser by the court. Whatever inducement may, or maybe inducement given to him, or maybe any influence given to him, in those conditions this confession is not acceptable. But if it is recorded, this confession for the police officer or the police machineries, it is a source of information from which the criminal law can be put into motion. So the police can use this as a source of information, but they cannot use it to prove it against the accused of the crime of which he has reported or he has recorded his statement. So this is where the section 25 is important for police authorities as well to begin the investigation into the right direction. Now there is a possibility that this confession may be made to any other person other than the police authorities. There are various departments in our country, such as NDPS narcotic department. There is a central excise department, revenue department, intelligence department, custom department, central excise department. Now these departments, there are inspectors. We may have heard the food inspector. We may have heard so many inspector, excise inspector. Now these they are not police authorities, but there are cases or there are I would say a system where the central government in consultation with the state government may give little power to these custom authorities or the central excise or various departments, maybe the NDPS authorities also, where they have a power to investigate the crime and also report and file the charge sheet. Now, see, if a police officer who files the charge sheet under section 173 CRPC, that means he has got a power under the criminal procedure code and he is a proper police authority. But a person who has not been given power of a police authorities under the CRPC code or under the Bombay Police Act, then he or she is not a police officer. So any statement made before them will not be a confession. It will not be a confession. Now to understand this, we can take one example of a police patil system in Maharashtra, where if you go to panchayat, there will be police patil. He is actually not a police authority. He is a police patil person appointed. Now here this person is not given any power to record any statement. He has also not been given power to arrest any person or to file a charge sheet. See, what is the test of a police officer? Test of the police officer that he has a right to investigate, arrest, and report or file a charge sheet under section 173 CRPC. Now, police patil in Maharashtra has no power. Now, in this case, where a police patil, before a police patil, a village person goes and say, I have committed a crime. Now, mind it, this statement will be actually, can be, this confession can be used because it is not made before the police authorities. See, section 25 is very useful. Now, anybody who wants to take benefit of section 25, he says, I have made a statement before the police patil, but this statement cannot be used. This confession that I have committed a crime cannot be used against me, then it will not happen. It will be used against him or her. There is a judgment of the Bombay High Court of State of Maharashtra versus Arjun Dattaram Bhekre. Now, in this, this is a murder trial. In this judgment, there was a statement made before the police party, and the accused wanted to take a defense that the whatever has been said before the police party and the person, this police party recorded his statement by and gave information to the police authorities and recorded an FIR. Then the FIR is a confessional FIR. It cannot be used against them. But the court said, Bombay High Court said, the statement made or the confession made by the accused before the police patil is an extrajudicial confession, and in case this police patil is not a police authority, so it can be used against them. Now here we have to remember that we have to clear this confusion that section 25 said any statement or any confession made before the police authorities cannot be used against him. But a statement made before the other people who are not police officers, maybe any witnesses, can be used in the court. And it can be used as an evidence, it can be brought as an evidence in the trial. Now we will see this judgment of Arjun Dattaram Bhekre. Here, para 17 is about little facts. I'll be reading out to you. So to understand what is actually the case. The second clinching circumstances against the accused is an extrajudicial confession made by accused number 1 to the police patil Ramdas Chavan. In his evidence, the police patil, the name is police patil, but he is not a police authority, stated that when he was at his house at about 8 or 8:30 p.m., accused number 1 came to his house. He was in a frightened condition. Accused Arjun informed that he had killed Yashwant Bekre. When he made a further inquiry from accused number 1, Arjun, he told him that he and his two sons had killed the deceased, Yashwant Bekre. They then proceeded toward the spot at Bhikrewadi, Mala. This version given by the police party is completely corroborated by his own FIR at Exhibit 14. In the FIR, it is mentioned that at about 8:30 p.m., accused number 1 Arjun came to the house of police party in a frightened condition and told him that before a short time at about 7:30 p.m. he and his sons Santosh and Atmaram had killed Yashwant. That the police party asked him as to why they had bitten Yashwant. Ekidmawal told the police party that Yashwant always used to practice witchcraft on them and therefore illness had entered into their house and their daughter-in-law had become ill due to such witchcraft and therefore in disgust he had killed Yashwant in front of the house of Parvati. The fact that this extrajudicial confession was immediately mentioned by Ramdas Chavan, that is the police party in his FIR, is also corroborated by PW number 8, the police officer who affirmed that he recorded a story as given by the police party in the FIR. The fact that accused number 1 came along with the police party PW number 2 is also indicative of the fact that accused number 1 had in fact gone to the house of the police party. In fact, in his statement under section 313 of criminal procedure code, this is very important. This fact is categorically admitted by accused number 1, Arjun, that he had gone to the police party and he had narrated the incident. But he has not said that, see, before the court, he has always said that it is not me who has committed the crime. But he said that he had gone to the police party house. And that is where the police party gone to the police station and narrated the story of the murder. Now here, there is one small para which I would like to read, which will give you a clear picture of confession to be used in the evidence, how it can be. We therefore agree that as section 25 Evidence Act, which engrafts a wholesome protection, it must not be construed in a narrow and technical sense, but must be understood in a broad and popular sense. But at the same time, it cannot be construed in so wide a sense as to include persons on whom only some of the powers exercised by the police are conferred within the category of police officers. Now, next para is most important part. The important attribute of police power is not only the power to investigate into the commission of cognizable offense, but also the power to prosecute the offender by filing a report or a charge sheet under section 173 of the code. Now here it is saying what is the police power. That is why this court has since the decision in Badku Jyoti Sawan accepted the ratio that unless an officer is invested under any special law with the powers of the investigation under the code, that is criminal procedure code, including the power to submit a report, that is charge sheet under section 173, he cannot be described to be a police officer under section 25 of the Evidence Act. Now this judgment in fact guides us that a statement made before the police party or any other authorities will not be a statement under section 25 of the Evidence Act. And this statement, there will not be ban. It can be used against the accused. But any statement before the police authorities cannot be used. So the test is that any person before whom a confession is made and this person has no power to file a charge sheet, then possibly that statement will not be a confession under section 170 under this section 25 of the Evidence Act, and it can be used against the accused person. So this statement is this judgment is actually very important, which actually takes out the difference between who is the police and who is not a police officer. If you read the commentary book on the section 25 of the evidence that you will be having one complete para which will is saying that who is a police officer. Now, as we discussed in the beginning, any person who has been given power, he may not be a police authority completely. It may be a narcotic department, it may be central excise department, it may be revenue or intelligence department, any or may be a paramilitary forces or a military army also. If they have a power to investigate and file a charge sheet, they will be police authorities and they will be governed by the section 25 of the evidence act. Now next we go to the one more judgment of the Supreme Court, that is Agno Nagasia versus State of Bihar. This is a very old judgment of 1965 from Supreme Court. Now, in this case, there were 4 people who were murdered. And just a minute, let me share this. This is also very important judgment. Agno Nagasia. Now, in this matter, 4 people were killed by this accused Agno. Now, when the matter went before the session court, it convicted because this Agno, after murdering these people, went to the police station. He recorded everything. In fact, this is also a confessional FIR. See, the meaning of confessional FIR is that where the accused, in a way of confession, saying that I have committed a crime and this is the way I have committed the crime, he gives the complete account of the what has happened, and he is the one who is giving the FIR. Now, if this is a confessional statement or a confessional FIR, can this be used against the accused? Now, in this matter, the trial court convicted 4 people were brutally killed by him, Agno. The High Court upheld the conviction, but he appealed before the Supreme Court by way of a special leave, where Supreme Court said that, see, there was no eyewitness in this matter. There was no other corroborative evidence. The complete trial was standing on the Agno's statement, and he himself was accused. Now, our constitution says, Article 20, that any person cannot be asked to stand as a witness against himself or in any incriminating evidence, to give any incriminating evidence against himself or herself. Now, here exactly this was opposite in this case. So, the Supreme Court said that confessional FIR by the accused cannot be used against him, and if the whatever statement or confession he has given to the police authority, recorded the FIR, which was recorded by the police authorities. Now, he was here also given thumb impressions. He was not even an educated person. He was not even aware of what he was doing. Now, the court came to its rescue that Section 25 Evidence Act says that if any person gives any account of the how crime happened and which increment himself or herself, that cannot be used against him or her. Whatever the prosecution has to stand. See, as a lawyer, as a layman, we may be thinking, if he has committed a crime, he is saying, I have committed a crime, why not convict him? But the Section 25 Evidence Act has been enacted to put a check on the police power, because there is a possibility and that police may misuse section any confession made before them. And if there is no Section 25 in the Indian Evidence Act, possibly there is that police may put pressure, police may influence the people to give an evidence against themselves or against their own relatives. There may be a husband has committed a crime, or maybe he has not committed a crime. We do not know the real situation. But when a wife goes, the police may influence to give an evidence that we will leave your husband if you give this statement. That is the reason Section 25 is very important. In this case, Agnu's case also, there were 4 people were murdered, but there was no eyewitness. The Supreme Court said the prosecution has to stand its own leg. Any confessional statement before the police, which was here an FIR recorded by the accused himself, it cannot be used against himself. So he was acquitted of the charges. So Section 25 is very important for defense practice if you are in the criminal trial. So whenever you open a charge, see if there is any statement by the accused and it is that confession can be is it the police or the public prosecutor or the court is taking it against you, then you should be very alert about this. Now here I would like to add one more thing. The statement or confession given under section 25 cannot be used against the accused, but if it is in a favor of the accused, can it be used? Yes, it can be used, and this is our duty as a defense lawyer, that it is in our favor. We can always use this uh, section 25 confession for accused benefit. There is a possibility accused may have narrated some incident, or there may be co-accused who have given some confession. This confession given before the police authorities can be used if it is in the favor of the accused. There is one judgment, Mohammad Fazluddin versus State, that is of Madras High Court of 2007. This judgment says that in case of confession to police, there is no bar to it if it is being used in favor of the accused. Also, there are sometimes admission given in the form of confession. They may say this property belong to XYZ. Now, this sentence from the confession can be used in the civil suits also. So, confession, which is under section 25 given before the police authorities, can be used in civil suit for the benefit of the parties. So, it is actually very useful section. Also, there are cases where section 25 confession, where co-accused gives any confession against our client. Now, in these cases, can the co-accused confession be used against the other co-accused? No, it cannot be used. So always remember that any confession given by whoever, whatsoever, in whatever situation under section 25 before the police authorities, or any person in the who has been given the power of the police as per the code of the criminal procedure code or any other special statute, can never be used against by that person. And any extrajudicial confession which is not given before the police authorities can be used, as we have seen in the Arjun Bhekre's case, where a statement confession was made. It was a criminal trial before the police party, and he is the one who recorded the FIR, and this complete FIR and police party statement which came later was used as an evidence before the court, and the accused were convicted with the benefit of this confession. So a confession which is made people before the police other than the police authorities can be used. That is the other part of the section 25. So this was all about today. I wanted to thank few people here. Vandana Chaudhary, who works with me. Also Vishnu Karle from the Latur, and from Nagpur, Archana Isankar. These people have been helping me to find out some good judgment. So